Let's move on then to this developing story. The Western Cape High Court has declared President Cyril Ramaphosa's decision to suspend Public Protector Advocate Busisiwe Mkhwebane invalid. Now, Mkhwebane's suspension has effectively been set aside from today. The Public Protector asked the High Court to declare certain conduct and or decisions of the National Assembly Speaker, the Chair of the Section 194 Committee and the President irrational, unconstitutional and invalid. Mkhwebane was suspended in June and is currently participating in a parliamentary inquiry into her fitness to hold office.
5-10 minute break. We need, sorry, someone has just walked into our room here, and we just need to have a quick consultation. We've just received a judgment from the Western Cape High Court that the suspension of the Public Protector has been set aside.
The suspended Public Protector, Busisiwe Mkhwebane, joins us now. I suppose then one can argue that you cannot call her suspended given what the court has said. But let's get some clarity now and speak to her about this particular decision. Advocate, thank you so much for your time this evening and for answering our calls at short notice. What is your reaction to the ruling?
Hi, Bongiwe, good evening. Good evening to your listeners and viewers. I am so thankful. I'm elated and thank God for, sustaining me. And yes, I'm very much excited. We are excited with the legal team that finally there is justice to this matter.
Which part of the ruling would you say for you, stood out? And I'm going to get to how you proceed in just a moment and even some of the arguments that were laid bare by the court.
Yes, I must also indicate that thanks to the public, thanks to everyone, the staff who were very supportive during this particular process. Part of let's start with the order, Bongiwe, which is very clear that this order is effective from today and which is saying the suspension is invalid. And that's what I would say is a very important issue. Another part of the judgment which the public should read and focus on is paragraph 157 of the judgment, where it found that the president hurried in the nature of the suspension of the applicant in the circumstances, notwithstanding that there was a judgment of the full court that was looming on the same subject, which leads this court to an ineluctable conclusion that the suspension may have been retaliatory and hence unlawful. So it was certainly tainted by bias of a disqualifying kind and perhaps an improper motive. And in our view, the president could not bring an unbiased mind to bear as he was conflicted when he suspended the applicant. So that is very key and critical in this particular matter because it was based on constitutional principles, but also the principles relating to common law, and it relates to the issue of biasness. So I think that's very critical to take note of. And I think it's very critical, Bongiwe, as well, that the court also indicated that me exercising my right by going to court also, it's not a sign of abusing the court process, but as well, it assisted the process.
I suppose then you feel vindicated by that particular line from the court, because they even continue to say, given the time frame between you going to court and waiting for that judgment, at the same time sending those questions to the president, that all of these events that unfolded then, the president has acted improperly according to them. I suppose you feel vindicated because your lawyers have been arguing this point in court as well.
Thank you. Yes, definitely. I feel very much vindicated with the team and indeed with my lawyers, because Remember, Bongiwe, this matter is it comes far back from the Abraham tweet and knowing the outcome of the Constitutional Court. And then the complaint was lodged by ATM in terms of the Executive Members Ethics Act on the 1st of, I think it was on the 1st of June. I don't remember the month. In fact, the complaint to the public protector was lodged by the ATM. And on the 7th of the month of June, I think we sent them the 31, so-called 31 questions, which I saw in the media all over. And yes, indeed, those questions were the questions we've asked. And I then made a media statement on the 8th that we have written to the president and we are expecting responses. Unfortunately, then my suspension came on the 9th of June, a day before the judgment on the 10th. I think even this court is indicating that, the president should have waited for the judgment. And also, it's very clear that this was kind of retaliatory in its kind. And on this objective fact, the court was saying it is the reasonableness to form the perception that the suspension of the applicant, which is paragraph 155 as well, was triggered by the decision of the applicant to institute an investigation against the president. There was no other plausible or logical explanation for the premature suspension of the applicant on the eve of the judgment meant to determine the very lawfulness of the suspension. And I think, Bongiwe, one of the critical issue as well is that, this is the hardship which, as the public protector and the environment one, we operate under, which even Chief Justice Mkhwebane said it in the Nkandla judgment that, investigating raw state power is very problematic. And because then one finds herself in such circumstances and trying to do my work, because we are trying to make sure that we investigate Executive Members Ethics Act related complaints within the 30 days. I know we're struggling to meet that, but then we also wanted to comply to the 30 days period.
So let's then look at this, because ultimately this particular, judgment, one could argue that, though, it may not have any effect until the Constitutional Court pronounces on the matter and put it to finality. I spoke to two analysts tonight, and they say that until it gets to the Constitutional Court, then you should not be celebrating just yet. Are you going to be going that route?
They are so wrong. The judgment is very clear. I think we also received a letter from the attorneys of the DA immediately after the judgment to our attorney, indeed mentioning that. And we indicated it very clearly to them that they are very wrong. Because remember, there's the part of the constitutional provision, section 172, 1B, because the letter which we wrote to them, we told them that even if the order was solely based on the conduct which is denied, especially what they are referring to, it is an order in terms of section 172, 1B, and not section 172, A. So we are even saying to them that thirdly, and for the avoidance of any doubt, the order is also based not only on the constitutional grounds, but also on common law grounds, including actual bias and even possible ulterior motives, that is bad faith on the part of the president, which would amount to a very serious violation of the president's oath of office. So this is based on common law, not only on the constitutional principle which is mentioned there. And I think that's what it is, Bongiwe. And as I told you, that the judgment is very clear, paragraph 187.6, that the suspension of the applicant is hereby set aside effectively from the date of this particular order.
All right.
Unfortunately, possibly is the desperation on the part of the DA. And I would want to assure the DA, I would want to assure the people of South Africa and the public and the staff of the Public Protector. By the way, congratulations to them. They've worked so hard. We have the third clean audit. And to the Deputy Public Protector who was holding the fort, that, let's just forget about all these things. I will still continue subjecting myself to this parliamentary process, but let's protect the public. That's what I'm there for. And I think, unfortunately, the DA might have their ulterior motives as well, and the issue of desperation.
All
but
right.
then I think I'm saying to the DA, let's just focus on the poor, the marginalized, and, ensure the issue of good governance in the country, and make sure that we all ensure that the public is protected from raw state power and the powerful forces.
Advocate Mkhwebane, I'm going to get to the acting public protector in just a moment, because there was a protest, a march to her office. But I want us to stay with this, because you say that, for you, there was, bad faith and all of that. But I want you to listen to this particular analyst, because I asked him that should the president appeal or this matter end up in the Constitutional Court, and could it stand the scrutiny of that particular court, and it still comes to the same conclusion? Please listen to this, and I'm keen to hear your response after this.
That the court would draw adverse inferences which may cast aspersions on the decision maker. And I think in this particular instance, the court seems to have drawn an adverse inference. Obviously, the timing of the matter is important. And as a matter of fact, yes, the president could have acted earlier. It may not be far-fetched that the letter, as the court found, prompted him to act swiftly. You must bear in mind, I think, that the suspension happened a day before a judgment was delivered. Of course, the judgment happened to be, against the public protector. So I suppose when the Constitutional Court looks at the matter, it will take those type of factors into account.
And there is a part where he also continues to say that he doesn't think, though, that it could be easy to prove, this bad faith that you're alluding to when it comes to the Constitutional Court. How do you respond?
Hi, Bongiwe.
Yes, I was saying that he then continues to say that when you then... can you still hear me, Advocate Mkhwebane?
Okay. Oh, you were freezing for some time.
Oh, apologies. So he was saying that while the issue of the timing is of course a problem, and the court is, right to make those inferences, it's not surprising. But when you get to a higher court, it may be difficult to prove some of what you have just argued when it comes to common law, when it comes to bad faith and all of that. How do you respond to what he said?
Bongiwe, I think it's so unfortunate that this advocate, Manya, the analyst, I think he should be quoting from the judgment. I quoted from the judgment. Can South Africans read paragraph 157 of the judgment and 155 of the judgment, where the judgment is very clear that, the issue of on these objective facts, it is reasonable to form the perception that the suspension was triggered by the decision of the applicant to institute an investigation against the president. And there was no other plausible or logical explanation for the premature suspension. That's what is in the judgment. That's what we argued. And as well, why rush to suspend when the decision of the court was expected the following day, where the court had to decide on those facts. So,
all right.
And paragraph 157 is very clear that this was something which was kind of, it's like it was retaliatory But Bongiwe, I think let's just not go there and allow analysts to mislead the public. And I think let's read the judgment and be sure that it's fine. And even if there is an appeal, there are processes which are followed for that. My legal team as well will deal with that accordingly, because there are provisions which also deal with how this matter can be dealt with whilst the appeal is being heard, whilst I'm still continuing to serve the public, because that's my interest. That's all what I'm interested in, Bongiwe, and nothing more, nothing less.
All right.
I'm here to just say that.
Let's wrap up then this conversation. There was a march to the office where you work. The report into the Phala Farm saga is not out. Opposition parties are up in arms and they want this report. What do you make of that that particular protest, and even the acting public protector saying that she still needs, more time to work on this matter?
I think maybe because the judgment is with effect from today, and if the judgment was out earlier, I would have been there as the public protector of South Africa to receive that particular memorandum. And yes, I've heard the public protector. Indeed, from today also, I will be requesting to be familiarized. Tomorrow, I'm going to the office. The hearing is proceeding. I'll be in the office whilst as well getting updates on all these particular issues. And there might be a plausible explanation why there was a delay. And as well, one will have to make sure that we strive to process matters expediently.
All right.
In a transparent manner.
Okay. And of course, we are out of time, but just in 10 seconds, what do you make of the headlines that have been made around the legal costs since you took office, and the fact that this is seen as wasteful expenditure? Even some of the commentary in the public domain saying that this is a bulk of your budget and you simply are wasting money.
Since 2016, that's the amount which was utilized, Bongiwe. And, you should also, or those who are concerned, they should be asking the very same speaker, the chairperson of the committee, especially the state institutions, the president, how much are they spending, Bongiwe? And that is within my right to do that. And remember, it's not only related to me challenging the legality of this matter, but it also relates to the matters which were taken on review. And those matters, we defend them. We are not going to court to enforce those reports. We are trying to defend those reports. And I think what DPP said there, that if political parties and NGOs can assist us to enforce the remedial actions of the public protector, we wouldn't find ourselves where we are. Again, it goes back to the Nkandla judgment, which we've shown over and over that the legal costs are there because we're trying to defend the matters. It's very few matters where I personally or I would be taking the matter to court. Unfortunately, it's wrong to say it's wasteful expenditure. There's value for money on that, and those costs have been audited. It's witnesses who are saying that, and unfortunately, some of the witnesses have said it, that there's no wasteful expenditure. There's value for money. I wouldn't be having the legal team defending me, particularly in this particular matter. We're wasting money.
Pardon me, Advocate Mkhwebane, we're out of time. I'm already in trouble. Thank you so much for your time this evening. I do appreciate it. That is Public Protector Advocate Busisiwe Mkhwebane. She says she's going back to the office tomorrow, and she says that that letter that came from the lawyers who are representing the Democratic Alliance, that this matter still needs to go to the highest court in the land for finality. She says for her that it's neither here nor there. The judgment, as she says, this was based on bad faith and also common law. So she is going back to the office, she says, tomorrow. And let's see then how this one unfolds. And we'll try to also reach out to the presidency just to get a sense of how, they are reacting to this particular ruling.